Dr. Nagpal, good evening.
Good evening, sir.
Good evening. I have made you co-host. Just to confirm that you can share your screen.
Okay, I'll just try. This is visible.
Yeah, we can see your screen. Yeah.
And the screen is moving.
Yes, it is. It is moving. Yes.
This is the biggest problem which comes.
Yeah, no, it is. The screen was moving, Dr. Nagpal.
I think last time we had faced some problems regarding the screen. Do you think this is useful for members?
No, it was very well appreciated last time actually. So it's already, I mean, that recording is there on our website. So I think there was a lot of positive feedback the last time.
Okay.
So I think from that point of view, we are okay. So you are not currently sharing your screen, isn't it? You've taken
No,
off the.
I'm not.
Okay.
You want me to keep the screen on? I'll do it.
No, just once to just confirm, just to confirm that it's actually also streaming on YouTube. So I just want to make sure that they're all working fine.
This is okay?
Yeah, this has come on Zoom. 1 second. Yeah, just leave it at that. I'll just see. Just give me a second. I think YouTube is happening. It just takes a little longer. I'll just confirm to you in a second.
Okay.
Yeah, it is coming, and the cursor is moving as well. So I think it's okay. You have gone to the second slide. Yeah. Yeah, it's streaming all right. It's streaming okay. It's just that I think there's a little bit of a lag on the YouTube part of it. So I think we're okay.
Okay.
How is so Chandigarh was not involved with all the election just over, or
No, Chandigarh was not involved.
so, but no activity in that area. It's all quiet. No celebrations.
Yes. Celebrations, of course. Aam Aadmi Party had good support this time. Because I have also shifted out of Chandigarh and into one of the suburbs. This is called Mohali.
Okay.
This is adjacent to Chandigarh border, continuous border with it. So this falls under Punjab.
Okay. So this is where the cricket stadium is.
Yes, the old one also, and there is a new one they have constructed now.
Okay.
That hasn't become operational yet, but that is a international standard stadium which they have built. So let's hope. Okay. I think because of COVID, it was not operational.
No, I think this thing keeps happening every now and again, and it's the whole day. I think the news has only been about the elections and arguments and counter arguments and fights and counter fights and
vicious arguments and counter arguments.
No, it is. No, they are not. There's no love lost anywhere. But I think they are all good co-workers. In the background, they all work together.
Oh yes.
Especially what posture they take publicly.
Absolutely. Most of them do business with each other.
Yeah. True professionals. So this rivalry, but otherwise they all look after themselves pretty well. A lot of doctors, I think a lot of doctors have joined Aam Aadmi Party actually. One of our neurosurgeons here that have joined. I think Santosh Karmarkar is quite involved with them as well.
The problem is not that. The problem what we see is doctors who join political parties start towing the party line rather than promoting the cause of doctors. This is a very unfortunate thing we have seen among doctor politicians who have, whether they are in the BJP or in the Congress, wherever. But they tow the party line rather than espouse the causes which actually we expect them to. So Aam Aadmi Party, I don't know how this will turn out. because this is not one of the established traditional parties. And so maybe,
No, I think I think I have not seen these firsthand, but whatever their Mohalla clinic operation supposedly in Delhi was doing quite well. I mean, I have no first-hand experience. All this is hearsay.
it's doing well. The Mohalla clinic experiment is doing well for the public. Doctors who were employed there had some complaints. There were too much interference by local politicians. But then I don't think that can be avoided if you're in government service.
Yeah.
Most of these people are contractual employees. That's another problem. They're not given permanent.
Okay.
So, I mean, issues are there, but yes, much better than many other established parties.
Yeah. No, I think especially during the last election here, there was a lot of professionals, the IT folk and the doctors, and a lot of them were actually all very enthused by the whole operation. They didn't win many seats, but I think there was a lot of excitement on the ground, at least among these group of people who otherwise are hardly participating in anything.
Yes.
So I think we have to see how they manage on a larger scale, because here they have complete independence. Delhi, I think they are still partly, majorly, controlled by a lot of things happen through the government, central government. Actually, it looks like from whatever.
No, they can hide behind the central government for a lot of issues. Okay. But individual states, the things will come to a head.
So I think they also have to learn pretty rapidly as they go.
But I think the path they are choosing is correct in the sense they are not hurriedly expanding everywhere. They are targeting, they are doing some groundwork before they join the electoral process.
Yeah. True. I think there needs to be there needs to be some opposition. Otherwise, it all gets carried away.
It's very important because, from modern scientific medicine doctors' side, the current strong central government has created many problems. I mean, decisions are politically correct. Now we hear MBBS courses will be taught in Hindi. I mean, this is something. Then similarly, Ayush has been introduced as part of the syllabus of MBBS, some 1 week or so training. These things, once introduced, these will be expanded and the next person may make it 1 year or.
Yeah. And these things are not reversible. I think once these kind of populist things come in.
Once this comes in, after that, you cannot take it back.
Yeah.
So, it is bull in China shop kind of something he gets into his head. He is determined. He goes ahead and does it. It works well in certain areas, but in this field, I think a wider consultation is probably needed before trying to impose.
Yeah. No, this is happening everywhere. Even in our state, they want to do engineering courses in the local language. I mean, so half, the whole population of engineers looks to get hired by multinationals and go to the US and go here and go there, and it's quite
degrees. Yeah. You are simply wanting to give degrees. You are not wanting to produce doctors.
Yeah, so I think the logic is different. I think Dr. Sareen has come online. Yogesh, good evening.
Hi, good evening, Sanjay. How are you?
I'm fine. Thank you very much.
Hi, Neeraj.
Good evening.
Sanjay, I'm okay. I just had a car accident, so I left my car in the workshop. Somebody banged their, from rear. So I just left it and just made home.
You lead an active and interesting life, Yogesh.
It's always like that.
Yeah.
How old was your dad, Sanjay?
He was 83. So, yeah.
He lost his father recently.
Acha.
Mm.
And how's your mother, Yogesh?
Fine. I mean, today she got her stitches out and she's walking around with a walker. She's a brave lady, you know. This is her 5th orthopedic surgery.
Well, to tolerate you, she has to be brave.
Yeah, it's the other way around, actually. Yeah. I have yet to see a more dominating person in my life.
Well,
I think-
unfortunately, you can have only one mother, so theek hai.
No, I think they are very resilient, very, very resilient.
She had her right knee replaced in 2006. At that time,
okay.
the left was not disturbing her too much. So, in spite of they telling her that you can have bilateral, she said nothing doing, and only my right is bad, do that. And now, after say, how many years? About 16 years, she got the left one done. She has a lot of orthopedic issues, that's all. Otherwise, she's fit and no comorbidity. When I carry comorbidity, she doesn't.
भाई उस जनरेशन ने बादाम खाए, हमने मूंगफली खाई, उन्होंने देसी घी खाया, हमने रिफाइंड ऑयल खाए. You can't be.
Yeah, and I think
So what are you talking
probably-
about?
Consent.
Okay.
No, I think they were also probably a lot more physically active than what we are. I think.
Yes, that is the main reason they could
Sedentary,
digest
yeah.
all this. And yeah.
Mhm. Despite whatever we think we are doing, we are, I think, essentially sedentary in our work. We might do treadmill, do running, do walking, but generally we are sedentary. Dr. Reddy, good evening. Dr. Milan Joshi, good evening.
Hi, Dr. Reddy.
Good evening, sir.
Last night, Sanjay, at 12:30, I joined a webinar being streamed from UK on DSD.
On?
It went on till past 2 o'clock.
Oh, okay. Their time, so okay.
Yeah, I don't think there was anybody else other than me from India on it. It was a lecture not by a pediatric surgeon, but by a psychiatrist who has been doing, a psychiatrist from USA, who's been doing a lot of work on ethical issues about DSD operated at a particular age. And
Okay.
he has created a lot of performers and grading scales, etc. And the bottom line, which I could understand, was that the recent study that they have done, it's half of the patients are very happy that they were not operated in childhood and they're given a chance to decide. And half of them said, we worked through hell. We went through hell because we were not operated in the childhood. So again, there is a dilemma with them now, whether they should look back into their own guidelines, which they worked out in early 2000, 2002, and whether they should do a larger cohort study to decide what is good. So they're talking about whether we should go back when the babies are to be operated in very early childhood, but there are others. But what I understand yesterday or today was that they were only talking about ethical issues of operating girls with CH having large clitoris undergoing a reduction, clitoroplasty. They were not discussing about anything else, but they did talk about the patients with proximal
We
hypotension.
we lost your sound.
Can you hear me?
Yeah.
But surprisingly, there was a lot of discussion on proximal hypospadias also. which I didn't know. I mean, because they were talking about DSD with proximal hypospadias and bilaterally descended gonads. I thought that they should not have discussed proximal hypospadias, whether it should be operated in early childhood or later. So they didn't have any answers when I questioned them. So I think even they are not very clear in many issues, and they're still working on things, you know. The problem with us is that we don't have that kind of backup with all that psychiatrists and everybody lined up for our patients.
Yeah, no, it's good. It's always remained a controversial thing. So I don't know how, and I think most of the recent debates have all been sort of responses to legal action by various patients and patient, advocacy groups rather than any medical issue being discussed. That was my feeling when you read whatever has been going on. It's all legal rather than medical.
When I was I was supposed to be giving an oration virtually in Pakistan Association of Pediatric Surgeons annual conference last year. So there was a talk about DSD patients there. And there also in the dais, there were a lot of lady doctors actually. I don't know why they chose to have most of the lady pediatric surgeons in that particular. And then there was a lady from Karachi who was probably an activist with some law background. And these doctors really hounded her, that you don't know a crap. And you people are kind of making too much of noise. The doctors decided. So for 45 minutes, they kind of, literally yelled at her. So I think still people are confused what to be done for such patients.
Yeah. No, I think there is still a long way from any consensus. I wonder whether we'll be able to reach some consensus. The problem is, I think even if we have some guideline, somebody doesn't follow the guideline, somebody goes to court, that judge might want to, give another contrary opinion. That's the whole problem here. There's no consistency.
I don't know about All India Institute of Medical Sciences, but I personally have done a lot of gender reassignment surgeries in neonatal age, at early adolescence. I've done a lot of gender reassignment. But the ones who are older, let's say 12 years old or 13 years old, I have done a lot of psychiatric evaluation. We would like to ask them to go to psychiatrists and be there with them for almost 2 years before we touch them.
Yeah.
And Neeraj will know, when Maharashtra banned all these surgeries, all of them, all those gays and lesbians, they would come all the way to CMC Ludhiana to get surgeries done by Dr. Abraham, A.B. Thomas did many surgeries in that area. But they were transgenders. They were not really DSD patients.
Yeah.
Hello, good evening, sir. Zamir here, sir. Hello, sir.
Zamir, good evening.
So this DSD, again, I don't know, because if we can we equate it to the society that we have in India and what we have in US and UK? I don't know, because the Indian society.
I'm very strongly opponent of whatever has been decided in Chennai, because right here in Delhi,
Yes,
close
sir.
to our house, I remember some uncle informed the Hijra community that the 21-year-old college-going girl of this family is actually a patient with ambiguous genitalia. It's not very recent. This was when I was going in 8, 9 class. And the Hijra community came and dragged that girl out of the house and took them along. So first, parents never kind of, made a formal complaint. And two, the police, even if they came to know Sumoto, didn't take any action. And this happens all the time in northern India. So I don't know what to do or what to subscribe to. Okay, it's already going to be 7 o'clock. Neeraj?
Yeah.
You ready?
Okay.
Yeah, I think it's 7, and we'll get going. I think I would briefly just introduce Dr. Neeraj Nagpal. This is the second of a series of talks that we are having on medico-legal issues that influence all of us. The last talk last month was basically an overview, which he classified depending upon various stages when a patient and a doctor interact. And now we are going one by one to try and see a little more in detail about each one of these. Dr. Neeraj Nagpal is a practicing gastroenterologist in Chandigarh. He owns and runs a hospital called Hope Clinic, and is also very well known for his activism as well as involvement in various legal and medico-legal affairs involving all of us around the country. So with that brief introduction, I invite Dr. Neeraj Nagpal.
Thank you, Dr. Rao. Thank you, Dr. Sareen, for having me again over here. The topic today that we had discussed and chosen was consent to tell or not to tell. This is frequently a question which is asked to me. Ki kya bataएं, kya na bataएं? It's a dilemma. Somebody will have to.
Yeah, I would just request. What I'm going to do, Dr. Nagpal, is I will just. Can I just request everybody to please mute themselves? And try. Please do not switch on your mics till the talk is over, please. Thank you.
The first thing to understand is consent. The way we have traditionally taken consent is we send a nurse out with a piece of paper and ask the nurse to get signatures on that piece of paper. For pediatric surgeons from the parents, and for others, for adults, from the patient himself. This is not a valid consent. Please understand this. And remember that in Indian law, consent is defined only in Indian Contract Act. There is no other place where consent has been defined. And a contract, you have to realize, is always between two or more people. So one party only signing a contract makes the contract void ab initio. It is not a contract if only one party has signed, which means when you send a nurse out to the patient to get a consent signed, and if the patient signs the consent and you have not signed it, that consent is of no legal validity. Please remember that there is something called agreement and there is something called contract. We have already mentioned that consent is a contract, but contract is enforceable. Agreement becomes a contract or consent if it is given by free will, without any coercion, without undue influence, without fraud, without misrepresentation, without mistake of fact or law. And parties should be competent to enter into a contract. That means they should be more than 18 years of age. And it should be for a lawful consideration. If I and Dr. Yogesh decide tomorrow to loot State Bank of Patiala, it will not be a proper contract. It will not be a valid contract because that contract is being done for an illegal and unlawful purpose. Justice Cardozo was one of the first people to give the statement on the principle of consent. In that he said that every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without patient's consent commits an assault. Now remember, assault is a criminal offense. So far, we do not have many cases, or to my knowledge, any case in India where on the basis of lack of consent, a criminal case has been filed. Yes, I do have certain incidents, but they are anecdotal, and at least the courts have not punished the doctors involved in these cases. Once the concept of consent came in 1914, after that the issue came, it is not only a question that the person has consented, it is also a question that the person should be informed what is going to be done, and he should be informed about what are the pros and cons. This concept of informed consent came in 1957. But this informed consent of US was expanded, and there is a differentiation now between real and valid consent and informed consent. In India, we are following the real and valid consent. This was what was the British type, and the informed consent is the US type. The difference basically is, what do doctors normally disclose? If all doctors normally disclose 5 complications of a particular procedure, and you have also disclosed 5 complications, then it is a real consent. But if a patient had been told a 6th complication, and that patient, based on that 6th complication, would have refused to get the surgery done, this is an informed consent. So the difference between both is what doctors normally do and what patient wants to know. Another important case in 2016 was also from, this is from Oklahoma Supreme Court. The doctor said he did not have any obligations to tell about alternative treatment methods outside his scope of practice. A foreign body injection came, he advised to the child to eat fiber, did not advise endoscopic or surgical removal. Now, in this judgment, it was added that this is equally, taking informed consent applies equally to invasive as well as non-invasive medical treatments and treatment alternatives, regardless of the physician's scope of practice. It does not depend whether you have the facility in your hospital or not. You have to tell them of alternatives, benefits of the alternatives, and all the negatives. The ultimate decision of what treatment a patient receives rests with the patient and not with the physician. So far, Indian case law is not following this, but we have been threatened by the Honorable Supreme Court that this may soon be happening in India also. Remember, we were following the British law where real and valid consent was concerned. But gradually, even the Britishers have shifted from real and valid consent to the concept of informed consent, where everything the patient wants to know is told to them. This 1985 judgment is the one which had mentioned that consent did not require an elaborate explanation of remote side effects. When you say this effectively means you tell them effectively what are the important side effects, and if other doctors are telling only those side effects, you are effectively covered. After that came this Montgomery judgment, which has said that it is not a matter of what the doctors think. What is important is what the patient wants to know. So even the Britishers are now moving towards a patient-centric consent. And would another reasonable patient have made a different decision if informed of that particular risk? This is the patient-centric informed consent. Samira Kohli judgment 2008 versus Prabha Manchanda. This is the standard judgment which has defined consent in India, and it is mentioned in this judgment that we need to take real and valid consent, but it has also warned of moving from real consent to informed consent if commercialization of medicine continues in India. The Jacob Matthew judgment, it has been referred to, and it is mentioned in this new Punjab and Haryana High Court judgment that even though it is the view of the mandate of Article 141, which says if the Supreme Court has given a decision, the High Court will not disagree with it. But this court is bound to follow the law laid down by the Honorable Supreme Court in Jacob Matthew case instead of Montgomery, which is a UK case, even though the latest judgment on the point is being a matter of judicial propriety. Effectively, the High Court is now wanting to say that we do not agree with the Boland's test, which is prescribed with the Boland's law, which is followed even in taking consent in the Jacob Matthew judgment. But still, because the Supreme Court is superior, so we are agreeing, we are not mentioning anything there. Another judgment came recently, Chirayu Healthcare. This is also an important Supreme Court judgment. And they have also mentioned very clearly this particular thing, that what other doctors do is not going to last very long. Soon you will be questioned on this issue, and what we had thought that what the patient wants to know is what is predominantly important. The Bolithos case was basically what brought about the change, and in this, the judge, before accepting a body of medical opinion as said to be responsible, reasonable, or respectable, the experts should be able to defend their opinion logically. So it was mentioned in this, and it has been carried forward in the Supreme Court judgment of Chirayu in India, that simply because other doctors follow a particular practice, it will not be acceptable if the court thinks it is not acceptable. One problem which arises frequently is, I am told, more than 10% complication is to be told. Where has this figure of 10% come from? This is a misconception. If you are doing cholecystectomy and you are having 10% complication rate, obviously you have no business to be doing cholecystectomies. The complication rate should not be as high as 10%. And here we are talking of complications which are more than 10%. So what effectively was meant in the particular judgment was 10 patients out of 100 develop some complications. Now 100 patients with complications, if develop in more than 10% CBD injury, then CBD injury has to be explained. But if only one person develops a stroke after a cholecystectomy, that stroke does not need to be told to the patient. This is the meaning of the 10% figure which is mentioned, and which sometimes doctors have heard in various medical legal lectures and have gotten confused on this issue. So it is not a complication which occurs more than 10% of the times in a particular type of surgery. It is a complication which occurs more than 10% of the times in all the complications which occur for that particular procedure. Another thing which Samira Kohli and Prabha Manchanda judgment had very clearly mentioned was, you have to secure the consent of the patient before commencing treatment from the patient. Consent so obtained should be real and valid, which means patient should have the capacity and competence to consent, which means the patient should be compos mentis. Consent should be voluntary, and consent should be on the basis of adequate information. One, the person should be more than 18 years, then he should be in his, the mind should be appropriate, and not, he should not be mentally challenged, he should not be under influence of alcohol, he should not be unconscious or delirious when he is giving this. The nature and procedure of treatment and its purpose, benefits and effects have to be told. Alternatives, if any available, have to be told. Any outline of substantial risks and adverse consequences of refusing treatment, all four have to be told to the patient. This is the composite of what consent is to be taken in India. They have mentioned very clearly there is no need to explain remote or theoretical risks involved which may frighten or confuse the patient and result in refusal of consent for necessary treatment. The court has recognized that health literacy in India is very poor, and if we scare our patients too much, the chances are they will not get the treatment, and that may not be in the interest of the society. Similarly, there is no need to explain the remote or theoretical risks of refusal to take treatment which may persuade a patient to undergo fanciful or unnecessary treatment. And it is for the doctor to decide so far, with reference to condition of the patient, nature of illness, how much information regarding risk. Important thing what was mentioned was, if a particular consent has been taken for a particular procedure, you cannot extend the procedure to do something else which you thought during the surgery as being important. But just because you thought the patient will not have to undergo another surgery, just because you thought the patient will not have to bear further costs or undertake further risk for repeat anesthesia, it is not your decision. If you have taken consent for one procedure, intraoperatively, unless and until you find a situation which is life-threatening, you cannot extend the procedure. You have to stop the procedure, come out, take a separate anesthesia for a different date, and go ahead and do do a separate procedure. This is unfortunate, but this is what the law stands today. Like in a hysterectomy, they mentioned very clearly, you inform about sterility, you inform about premature menopause, you don't need to inform about ureteric injury, vesicovaginal fistula, fatal hemorrhage, anesthetic death. Rare things you don't need to say. Similarly, more judgments I can quote where this issue has been decided on, that you have gone ahead and done further. Like in this particular case, MTP was done along with the laparoscopic tubal ligation, and perforation of uterus was noted following MTP. Repair done, intraoperatively decided to remove an unhealthy appendix. While removing the unhealthy appendix, rectal perforation occurred and peritonitis occurred, which required surgery at another hospital. So there was no need for the doctors to undertake the appendectomy. Another interesting judgment regarding consent, this Vinod Khanna versus RG Stone clinic, this had become a very popular. Basically, in this, the National Commission had mentioned that if you are having a pre-printed consent, a pre-printed fixed informed consent cum undertaking form with blank spaces for limited select handwritten entries and for signatures has been used. It can fit any procedure, any doctor, any patient. No names have been mentioned, and uniform use of this pre-printed and fixed informed consent cum undertaking form on the part of opposite party to be unfair trade practice. Very interestingly, in this judgment, the court used the words, the consent which has been taken is informed consent. Now we require real and valid consent. They say this is an informed consent on one side, but simultaneously they have criticized its used as a pre-printed informed consent and undertaking, and they have penalized the hospital for using this for unfair trade practice. Fortunately, the hospital, I mean, we were preparing to take this matter to Supreme Court, but the hospital itself went ahead, and Supreme Court heard the contentions of the petitioner and has stayed the direction of the National Consumer Dispute Redressal Commission with regard to pre-printed forms. This has not been overturned, it has been stayed, the matter is still going to be heard. There are instances where withholding information is justified. A waiver situation is when a patient expressly indicates that he does not want to receive further information. This unfortunately may be true for West. In India, it is very common for us to hear, Doctor Sahab, jo aap sochte ho theek wo kar dijiye, hamari taraf se aapko puri ikhtiyar. Now, before the surgery, this statement is universal. After a complication occurs, we face the problems of not having told the complications. So then in medical emergency, when life-saving treatment is required and patient is temporarily lacking decision-making capacity, definitely you don't require to take any consent. What to talk of telling about the complications, which complications will occur. And therapeutic privileges. When a patient's decision-making capabilities are impaired so much that the very act of giving particular information would cause patient serious physical or mental harm. Now, the patient has an anxiety disorder. This is what the courts say. But when you go ahead and actually see, because all our patients tell us, or their relatives tell us, Doctor Sahab, agar cancer ho to patient ko nahi pata. This becomes a very tricky area. And I really don't know, this requires a lot of debate. I have my views on this issue. So the questions are, who should sign the consent? If husband, brother, sister, father, wife, somebody is signing, is that adequate? Whether consultant or nurse who has taken the consent should also sign. Pediatric patient, who should sign? Consent for procedure which would cause sterilization, who should sign? Language of consent, when should consent be taken? Role of witnesses in consent. Consent for multi-stage treatment. Can patients refuse to get procedure after a consent? On one side, we have said it is a contract which is enforceable. But yes, our patients can give consent today and just on the operation table can refuse to get the surgery done, and they will be within their rights. So enforceability is only one way, in that the doctors are bound by it, not the patients. Consent in emergency situation and consent for special requests. Doctor Sahab, mera cesarean jo hai wo 11 तारीख को 11 बजे होना चाहिए. These are special requests which gynecologists are very, very frequently hearing. And remember, consent is not one document. It's not one page which you have got signed. It is a constant communication and documentation of that communication, which is consent. Unless and until we do that, it is not going to be valid. Remember, in Indian law, the IPC section 92 says, act done in good faith for benefit of a person without consent is not an offense. So ideally speaking, a criminal case should not be filed against a doctor for not having taken proper consent, if you go by this. But as I will show you, we have certain anecdotal cases where this has happened. And who should give the consent in non-emergency situations? Because Indian law, as I have mentioned in many of my talks, is very, very confusing. At 18 years, a boy can adopt a child. He cannot get married till 21 years, and he cannot have his first drink till he is 25. This is law in India. Similarly, Section 87 says a person more than 18 years can give valid consent. Section 89 says a child under 12 years age cannot give valid consent. Very good. What happens between 12 and 18? We are silent. Then Indian Contract Act says every person who has attained the age of majority is competent to contract. And Indian Majority Act says every person attains the age of majority after completing 18 years. So between 12 and 18, we are silent. And remember, in pediatric patients, consent of any one parent is valid and binding, even if there is disagreement between the parents. If you leave columns blank, basically less than 12 years, you have to take signatures of parents. Between 12 and 18 years, you should take consent both from the child as well as from the parent. More than 18 years, the consent has to be taken only by the given only by the patient. If you leave many columns blank and they are not filled, this will not be considered a proper consent. What happens in the Aruna Shanbag case, because this is a very major problem in consent, that the life support treatment, what is to be done for that? And Aruna Shanbag, I hope everybody is aware of this particular case where the nurse who was raped and was murdered by a hospital worker was kept alive and in a vegetative state and cared for 17 years by KEM hospital staff. Finally, a friend of her had approached Supreme Court and asked for permission to end her agony by stopping the life support measures, though it was basically to stop the feed and she was not on a ventilator. So this became a landmark judgment. And initially, prior to that, Gyankor versus State of Punjab was a case in which the court had held that right to life under Article 21 does not include a right to die. But in Aruna Shanbag case, the Supreme Court held that passive euthanasia can be allowed under exceptional circumstances. And it also said, but the procedure laid down by Aruna Shanbag judgment was to approach the High Court under Article 226. On application, Chief Justice forms a bench of 2 judges. They take opinion of 3 doctors nominated by the bench, and panel of doctors should be prepared in every city, all this. So the entire decision had to be given by the courts in 1 month. This was an impractical thing, but this was the judgment which was given. I do not know many cases which have been similarly decided. After Aruna Shanbag case came the Common Cause Society versus Union of India. And in that, they extended the issue because it was obviously not practical for everyone to approach the High Court, and it was not a question only of passive euthanasia. There were many issues which were not decided. Most important issue which was decided in this Common Cause versus Union of India was a question of living will. The person, whether a person is permitted to sign beforehand and say that he does not want XYZ type of treatment in case he lands up into one particular type of a problem. So the court agreed that passive euthanasia is permitted. And in cases of incompetent patients, best interest principle should be applied, and such decision should be taken by specified competent medical experts, not by High Court as mentioned in Aruna Shanbhag case. And this should be implemented after providing a cooling period to enable any aggrieved person to approach the court of law. Now, an advance medical directive, this is what the living will is an individual's advance exercise of autonomy. How is this to be taken? It is like you prepare a will. You have to have two witnesses. It has to be done in front of a tahsildar or a judicial magistrate first class. It has to be registered in the office of judicial magistrate first class. And it should mention particular number of things. Only then will it be regarded as a advance directive or a living will. You have to ensure patients' directives are written, take high-risk consent from the patient still. Patient's consent should be taken in presence of minimum one independent witness. Record specifically in consent the patient's directives. Be sure that conditions for invoking an advance directive intended by patient have occurred before acting on the same. If in doubt or dilemma, act in best interest of the patient. This is a huge procedure. The question of whether to remove a ventilator or not, I can carry on, and this is a full 1 hour lecture, but this is basically covered under Common Cause Society versus Union of India, this decision of 2018. Whether a DNR form can be signed, do not resuscitate form can be signed. At least one judgment is there from National Consumer Dispute Redressal Commission, which has upheld a DNR form which was signed. And this issue of removing the ventilator, problems of this are not seen only in our country. You look at this case where severely brain damaged patient with poor prognosis was removed from a ventilator and later from nasogastric tube with agreement of the family and physicians. Now another caregiver comes, alleges that you have withdrawn both treatments as part of a conspiracy to kill the patient and hide malpractices. Very, very commonly we find this in India. The persons who are the caregivers usually are the daughters or maybe the local sons, and after the death, some NRI will come and start blaming you that you have conspired with my brother or with my sister to kill my father. At least in my career of 30 years or so, I have faced one such gentleman who was never seen when the father was being treated for 5 years by me. But after, when he died, after that, suddenly he appeared to become in charge of everything and started questioning. So basically, for consent, the law requires disclosure to the patient of information relating to diagnosis of disease, nature of proposed treatment, potential risks of treatment, and consequences of patient refusing suggested line of treatment. What degree of disclosure of risks best left to clinical judgment of doctor? This is as of today. Imagine Apollo Hospital Chennai was penalized for not declaring in the consent form that they do not have facility to monitor methotrexate levels. This is something which is strange, but then nobody has challenged this, so this remains valid. This, you have taken a written consent, everything has been done, consent has been taken from the wife also and the husband also, based on CA 125 levels and other reports. For the hysterectomy and BSO was done. The histopathology once done of the resected specimen, it showed there is no malignancy. Now the complainant says, Kiji, I was in a frame of mind that this is not a valid consent which was signed by me. Consent not taken for a common complication. If the complication is common, definitely you should be taking. Consent not taken for a minor procedure. You have not taken a consent because you think the procedure is minor. We had another case of a senior gastroenterologist in Mumbai who did not take consent for ERCP from a patient who himself was a surgeon. And the defense he placed was that the patient himself was a surgeon. He knew all the complications. That is why we did not take the consent, but this was not accepted by the courts. Then consent not taken for oral pills and non-surgical MTP. you require to do that even for non-surgical MTPs. Similarly, for chemotherapy, with sessions of chemotherapy, the weight loss occurred, and the dose which was being given, since every time it was not being checked, it became higher, and the patient went into CCF. And the relative sued that you did not inform us of the complications which could be occur. Similarly, look at this particular case. Now, this is an example which I said earlier of an anecdotal case where criminal case has been filed for not taking consent. What the consent was not taken for? The patient was not informed that you are being started on hormone replacement therapy, which is an oral therapy, and this can result later in you developing infiltrating carcinoma breast. For this, a criminal case was filed. Judicial Magistrate First Class Sessions Court refused to quash the FIR. The matter came to High Court. Finally, the criminal case was quashed, and the civil case continued against the CNC Vellore authorities. Then there's a confusion in people's minds whether consent is needed for asking for a postmortem. In cases of suspicious or unnatural death, no consent of relatives, friends, attendants is needed to refer a dead body to police for postmortem. The National Commission has mentioned very, very clearly in this, autopsy is a must in case of sudden unexpected death. Your duty finishes once you inform the police. After that, it is between the police and the relatives what they do, but please maintain a record of which policeman at what time, by what modality was he informed about the situation. If a surgeon is only going to perform surgery and thereafter other doctors will look after treatment, like many senior doctors who perform the surgery, they have to go for a conference to USA. This should be mentioned in the consent that the patient will be looked after surgery by such and such doctor who is also equally competent or who's also qualified, or the team, the junior members of the team of the doctor concerned. Usually, this clause should not apply on government hospitals, but this is advisable that in the consent this fact is mentioned, because we do have many cases where this kind of a situation has arisen. Then, in this particular case, hysterectomy was done. Patient was transfused 2 units blood, probably containing HIV, but no separate consent for blood transfusion was taken. Please remember, when you are taking consent for surgery, there is one consent for surgery, one consent for anesthesia, one consent for blood transfusion. All these 3 should be separately taken. Then, another very strange judgment had come from National Consumer Dispute Redressal Commission. This was against Maharaja Agarsen Hospital, in which it said that ERCP is the most dangerous endoscopic procedure which deserves detailed discussion, and endoscopists should use their own complication data, as legal concept of informed consent requires open and honest discussion of risk. If Dr. Yogesh tomorrow is training a junior, he's doing his MCH in pediatric surgery, and the person has to be given his second case of hypospadias has to be operated, what is he going to write in the consent form? That I have 100% mortality if his previous patient died. How can, nowhere across the world is the surgeon's complication data required to be entered in the consent form. But this particular judgment says that, and this has said it for ERCP, but this is extrapolated everywhere, and we have not challenged this. So this is an unfortunate judgment which actually should have been. Similarly, if you have taken consent for doing a surgery by one particular method, please do the surgery by the same method. Don't change the method. If you are taken consent for open, don't start doing laparoscopic. If you have taken for laparoscopic, don't start doing something else. The point remains, if you need to change from laparoscopic to open, mention this factor in the consent already. Under certain circumstances, depending on the findings inside, we may need to resort to open surgery. Then it is perfectly okay. Otherwise, yes, you will have to pay compensation. Similarly, in this particular case, relatives of the patient did not consent to putting the patient on ventilator. Opposite parties never informed the relatives that patient was brain dead, and keeping brain dead patient on ventilator is negligence. The judge says, in absence of any consent in writing, I am of the considered opinion that OPs were deficient in services. I fail to understand, when we try to put a patient on a ventilator, it is an emergency. On one side, we say we don't require a consent when we are doing a life-saving procedure. What is bigger life-saving procedure than putting a patient on a ventilator? But the Judge Sahab, Honorable Judge Sahab in this case, he wanted a consent from the patient in writing before putting the patient on ventilator. Interesting. But yes, we have certain judgments which we can use for our defense. This is one of them, Allahabad High Court, recently 2019, which said that if you have given consent for surgery, it is also consent for consequences, and you cannot keep blaming the doctors. Refusal of consent. If you have advised patient cesarean and the patient is not getting it done, you better get the patient to sign a refusal of consent. If you're not getting a patient is not signing the refusal of consent, note down in the medical records, patient has been advised surgery, patient is refused surgery, you sign, make a staff nurse sign over there or any senior doctor who's nearby to sign it, so that it is documented. And onus to prove informed refusal lies with the surgeon. You cannot claim that we advised and the patient refused. Then, in this particular, can the consent be taken by somebody else? Here, the Samira Kohli case, which India follows, this mentioned that a junior member of the team can take a consent. But ultimately, the person who has explained the consent has to sign, and it has to be mentioned who is going to be operating. Similarly, the issue whether husband and wife both have to sign for an MTP, the Supreme Court has upheld the right of a woman to undergo an MTP without having a husband signing it. Then we have confusion regarding sterility surgeries, regarding surgeries for tubal ligation, where government is saying one thing and Indian Medical Council regulation is saying another thing. Video consent, I know there is a lot of fashion of doing a video consent, but it is mandatory only under Transplantation of Human Organs Act. And remember, if the patient is signing in Marathi or is signing in Punjabi, make sure the consent is written in Punjabi, or ask another educated relative to write a single line in English that I have gone through the contents of the consent, I have explained the consent in detail to the patient, and he has understood the same, and let the relative sign and write down what his relationship is with the patient. Because somebody signing in a different language and your consent is in English is not acceptable. Proxies, can somebody else give a consent on behalf of the patient? Yes, for minor, incompetent, emergency patients, spouse, biological parents, blood relatives, any relative who has brought patient to hospital. So this, and you have to record specific reason for obtaining a proxy consent, especially if the patient is 18 years or more. Thank you so very much. I hope I haven't exceeded my time.
No, I think you're dot on 40 minutes time as we had agreed. I will open this to questions. I think before we start, I think since I think the Samira Kohli judgment, I think was one of the primary driving forces of how consent is actually taken these days. I just for the benefit of those who are not familiar, if you could just briefly describe the series of events that happened and the consequences, while I just check out the questions that came on the chat.
Basically, the patient was taken up for diagnostic laparoscopy. During diagnostic laparoscopy, they found frozen pelvis because of endometriosis and adenomyosis. Now, the thing was, they sent a junior doctor outside to talk to the mother that this patient requires hysterectomy. The mother gave the consent in writing. The doctors went ahead, did the hysterectomy for the patient. Everything was all right up till 7 days after surgery. 7th day, a gentleman came. Now, this lady, please remember, was 44 years old. And At that age, removing the uterus, this gentleman comes and says, I am the fiancé, and you should not have removed done the hysterectomy in this patient without proper consent from the patient herself. So basically, and the issue of the billing part came in. The hospital actually filed a case for recovery of the bill, following which this case was filed on the lack of consent. So the issue was actually probably not so much regarding the consent not being taken for hysterectomy, but this became a landmark case. Only 25,000 rupees as penalty was awarded, though freedom was given that the separate case can be filed for enhancement of the penalty. And the issue which was decided here was, you have given the patient anesthesia, you have taken the consent for a particular procedure. During the procedure, if you do not find anything which is life-threatening, do not proceed to do something just because you feel it is in interest of the patient. Earlier, when we were doing our trainings, routine appendectomy, routine tubal ligations, if a lady had had 5 surgeries, our boss would routinely perform a tubal ligation. Now, all these things, they have been, you have to withhold your hand, even though you think it is in the best interest of the patient. Giving a second anesthesia is unnecessary risk for the patient. It is going to cost the patient more. All these factors are mentioned very clearly in this judgment, that these are not your decisions to take. If there is no life-threatening emergency, don't do anything beyond what is. Now, this has another implication. Remember the VP Shanta and others' judgment. Don't forget that. What had that said? That had said contract of personal service is not included within the definition of service. And what is contract of personal service? Where there is a master-servant relationship, which means I am contracted to do what you tell me to do. I cannot go left or right. I cannot use my own mind. If I cannot use my own mind and I have to do what you tell me to do, this becomes a master-patient relationship. And Samira Kohli judgment has changed a professional relationship into a master-patient relationship. The patient has dictated in her consent you to do X. You are doing X plus Y. This is something you cannot do. If that is the situation, then I think doctors do not require to be covered under Consumer Protection Act at all. So this is a branch off from what we were discussing, but the fact remains this is a very important issue, that the professionals do not have a professional leeway to do what they think is correct under the situation, and it is going to be dictated by the patients. It's very unfortunate, but this is what the situation is today.
Yeah, thank you. I think Dr. Sareen has his hand up. There are a few other questions on the chat, which I will take once Dr. Sareen has asked his.
Neeraj, there is something which I often tell my residents not to do it, but it used to be kind of very rampant when a sick patient used to go for surgery. They used to insist, the anesthetist, that we should take on-table death consent. I mean, this is not written in textbooks or papers, but what I feel is if you say on death table, that means you kind of are not sure that you'll be able to save the patient, but this kind of consent probably can get you into trouble.
The consent will not get you into trouble. The consent will not get you out of trouble. Just because you have taken that consent, it is something like writing, this report is not valid for medico-legal purposes. It doesn't help you.
Right. The second thing is about pediatric. I mean, I've done a bioethical course recently. The children from 7 to 12 years can actually give what we call as oral assent. And from 12 to 18, the consent that they give, of course, along with their parents, is called written assent. So that age group is now defined. 7 to 12, oral also is okay. You record that I talked to the patient said that. And from 12 to 18, of course, it's more like a consent only, but it's called assent as far as the children are concerned.
Thank you. There is a question. It says that in an institution-based practice where there are multiple consultants, one consultant may have seen the patient in the OPD and another consultant may have actually performed the operation. So does the patient need to be specifically informed that this is the way, or can more than one doctor sign the consent?
So, see, in a government institution, it is going to be next to impossible to decide who is going to operate. But in a private sector, the doctor who is going to operate has to be specified very clearly. Please remember Dr. Desai's case from Tata Memorial Hospital. This went on for 26 years. Patient was his. He was not operating. His junior was operating. He was informed on opening the abdomen that this thing is plastered with malignancy and we can't do anything. And he said, without having seen the patient, that you close the abdomen. Now, the patient was his. So effectively in private sector, what you need to do is, it is very, very important that who is going to operate, the doctor's name has to be mentioned. After surgery, who's going to look after the patients? The doctors of the team, either you mention a word like that, qualified doctors of the team, like if it's a urological operation or if it is a pediatric surgery which has been done, the consultant who's going to operate, his name should be there. You may not write the name of all the entire team members, but other qualified, equally qualified members of the team will be looking after the patient after surgery. This is something which has to be included there. The person who sees in the OPD, it is not important that consent be taken for who's seeing the patient in the OPD. But consent has definitely to be taken for the doctor who's going to be operating.
Thank you. The next question is, any guidelines for OPD prescriptions, as there could be side effects?
Sir, I have given you an example where this was an OPD case. The CMC Vellore case was an OPD case. Basically, this patient was on cyclophosphamide. She developed menopause. She was sent to gynae department, and the gynae department started hormone replacement therapy. This was totally OPD-based prescriptions. And the whole issue came up because 2 years down the line, the patient developed infiltrating carcinoma breast. So you do need to mention at least in the if there is something like azathioprine or something which can lead to some bone marrow suppression or some major complications can occur. Some of these things have to be informed to the patient, or at least a single line can be written that risks and the complications related to the medicines have been explained to the patient. But again, it should not be pre-printed, because that would appear as a formality.
So then I think there's a question, are pre-printed forms allowed at all? I think most hospitals have pre-printed forms with lines where they fill in.
So the thing is, this judgment was wrong. You have to have pre-printed procedure-specific forms. The difference is, it cannot be blank. It cannot be bland. Any surgery, any doctor, anywhere, that kind of a thing is not permissible. You should have printed forms, but they should be procedure specific. You have one consent for cesarean, you have one consent for hypostadia surgery, you have one consent for XYZ, whatever you wish to do. And the complications obviously will be related to that particular surgery. So you have to have procedure-specific consents. Whether they are printed or non-printed is not the issue. You cannot actually have non-printed because you cannot write everything. It's not practical.
The next question I think is something related to intersex. It says for genital surgery like gonadectomy or vaginoplasty in intersex, can a child more than 12 years give consent? It says Malta judgment says 12 years of age, patient reaches maturity to decide on gender and can give consent.
Sir, Atlanta is not going to be the one to be trying your case. Your case will be tried in India. Please follow the law in India. We can give guidelines as given abroad, but that doesn't apply to Indian courts, and Indian courts are very clear on the issue. Less than 12 years, a person cannot give consent. More than 18 years, he can give consent. Between 12 and 18, take consent from the child as well as from the parent. There is no question in this.
Then I think the next question, I think again is based on a similar recent story, which came in the papers about somebody with spina bifida. So a patient with lifelong grave prognosis about limb movements. Parents gave consent for procedure despite knowing everything. Later, child grows up and challenges the decision. Who will face the penalty, and has there been any further progress on this? Any judgment?
So there is no way you can, because effectively the problem with this judgment is the issue of how long to keep medical records. The consent part is not the issue here, because by law, if you have followed the law and taken consent of parents for performing a surgery on a child, you have done what was required. Yes, it may be possible, it may have been better, you may have discussed, or oral assent, as Dr. Yogesh mentioned, be taken with the child. But obviously the child at that age, especially in our country, is not aware or not health literate. Our 60-year-olds are not health literate. What can we expect from the children here? There is so much confusion regarding these issues. The issue which will arise will be regarding how long do you keep records of these patients who are pediatric, whom you have operated. Should you keep them for 3 years after they attain the age of maturity? Which means, supposing you have operated a patient at 10 years, should you keep the records for 8 plus 3 years? Because the law of limitation says 3 years from the cause of action. 3 years from the cause of action, and the person gains at maturity at 18. He becomes capable of filing a case against you when he is mature. So should you be keeping records that long? The answer to that is, again, when we will be doing the next one, hopefully on medical records, we'll answer that there, but I'll give you a gist here. Because law is confusing, what we recommend is something I have devised called Nagpal's rule, which says that every year give in 2 different newspapers, one English, one vernacular. Newspapers should be such which nobody reads. They should not be mainstream newspapers. Newspapers should be such which nobody reads, but give 2 advertisements that you are going to destroy the records of more than 5 years old, which are lying in your hospital. Anybody interested can come within 30 days and collect those records. Nobody will come, or somebody will come, whatever the situation. Do not destroy your records after 30 days. Keep them. You have a case filed 18 years later, 15 years later. When you go to your advocate, take the advertisement as well as take your medical records. If your medical records are good, fine. If your medical records are not good, the advocate will use the advertisement to say, we gave an advertisement before destroying the records, so we do not have the records now. So basically the issue which will arise will be regarding the records. It will not be regarding the consent part.
Neeraj, one more thing that I remember very clearly from my experience in Maulana Azad. In Lok Nayak Hospital, when we used to admit patients, there used to be an admission form which clearly used to state that although this admission is being done under the name of the unit in charge or head of the department, anybody from the team can operate. Now, this is really not a consent. This is when he gets admitted, that is done, you know. And of course, when you do the surgery, you write the consent, and wherein these words were never written, but they were 2 different kind of papers. Would the first paper that was done at the admission, which does not have any signatures of the doctors, which does not have any signature of the witnesses, be valid or not?
It simply will be there as a supportive document to show that the patient was made aware that no one doctor is going to be operating, a member of the team will be operating. It is simply a supportive document. If the patient wants to challenge that as not being a proper consent, he will probably succeed. But for that, you will also need to take a second consent before surgery, and that consent will be valid. So when you take the second consent before surgery, you will be writing over there who is the operating surgeon. So the matter is finished after that. Then you don't require this original document.
Another question is that I don't know whether you will take it today or maybe some other talk of yours. whether vicarious liability of a person who is junior in your team, whether it is a government institution or a corporate hospital where you had no, role in choosing the person who will come and work with you, and you have to, of course, get the work done out of the residents and others. So would you discuss that today, or would you take it up some other talk of yours? Vicarious liability, because I've had a case for somebody who tried to do a cut down and he cut the brachial artery. He remembers Diana, we used to call ABC, arteria, basically that arterial cutters, if you come on that club, you're really shamed. But it has happened that one of my juniors in the night, when he probably saw a patient in shock, didn't even ask me whether I should do a cut down, and did a cut down and cut the brachial artery. And when the court case came, I was kind of questioned.
Vicarious liability is a huge topic in itself. You cannot deny your vicarious liabilities since you are the person in charge, and the person who's joining you as a resident is supposed to be working under your supervision. We cannot deny the liability there, but the fact remains that way even the hospital will be liable, the head of department will be liable, the person will be liable. But the classical example is an intern is starting the blood. The blood has been given by the blood bank in charge. The blood has been brought by the relative of the patient. The blood has been informed, it has been informed to the house doctor in charge of the ward. The house doctor instructs the intern, you go, the blood is lying over there, you transfuse the blood. The blood mismatch occurs. The vicarious liability part, you cannot escape. Even the head of the pediatric department was roped in. Now, when the case comes for arguments, you can argue that this is not a thing in which my personal supervision was needed, and this is something which is a complication, can happen at times. I mean, if the arterial cut down has been done, obviously the BP was low, and the artery may not have been pulsatile and may not have, there can be many reasons. After all, giving intrathecal vincristine instead of intrathecal methotrexate, this classical example which you have, this has happened in more than 6 continents, in more than at least 55 hospitals. So effectively, there are situations where arterial cut down will happen. It may be because of negligence, it may be because the resident is overworked, it may be because of many factors, and many of them will be systemic factors, may not be individual negligence. But the fact remains that vicarious liability is something which the patient party will definitely try to rope in as many people as possible.
Thank you. There is another question here. If there is a difference among parents of a child for giving consent, whose opinion, how do we go about it?
Consent of one parent is more than adequate. You don't require consent of both parents to operate on a child, number one. So the question is, whom do you choose, father or mother? You are nobody to choose. Whoa. You are nobody to choose. If there is a friction in the hospital, ask them to approach the courts, solve their dispute, and then come for the surgery.
There is again, I think, a couple of questions. I'll just finish with this. I think it says about, there is a sick patient in emergency, ventilators are not available, attendants are not giving ambu bag ventilation consent. Or similarly, there is an unexpected complication during surgery and the patient needs ventilation. Ventilation is not available. We have not taken consent.
So consent for ventilation should always be taken, number one. Number two, for a life-saving procedure, for an emergency, if relatives are not giving consent, all you need to do is you need to document in your medical records that this has been advised and the patient's relatives are refusing to give consent for this, and you can have some witnesses sign, or even if you witnesses don't sign, even then your own medical records in the routine course of event, the way if you write your medical records, if you have written 1 hour ago the status of the patient and you're writing this thing now and you are writing something again half an hour later, so it becomes in the routine course. You have maintained these medical records and they will be sufficient to defend you.
Right. I think we are sort of coming to the end. I think just to summarize, I think that slide that you mentioned that consent is not a document but a process that has to be documented over time. I think should be the sort of take-home message about what you are talking, because I think from all this discussion there is no one standard. It varies patient to patient. It varies depending upon so many factors. So there is no one. And I think that point that you made, that it has to be continuous communication that is documented, perhaps is the most important. So with this, I will close this meeting. I think we have stuck precisely to time. Dr. Nagpal, thank you very much. It's been very, very informative. We have had about 65 plus between here and the YouTube people participating, a lot of questions as well. So thank you very much for your talk, and I'm sure that we will continue this series over the coming months. Thank you very much.
Thank you.
Thank you. Good night, all of you.
Bye.